Hi students, this is Hari Naganan, Shorthand instructor. Now I am going to dictate a passage relating to 100 words per minute. Ready? 1, 2, 3, start. The case of the plaintiff in brief is that the defendant number 1 is a member of the chit of the plaintiff's company, being highest bidder availed an amount of rupees 40 lakhs, agreeing to forego an amount of rupees 14 lakhs out of the chit value. As on the date of the payment of price amount, the defendant number 1 paid rupees 8 lakhs. He furnished defendants 2 to 5 as guarantors for the future liability of 32 lakhs and executed an agreement of guarantee on 24/5/2007. All the defendants executed promissory notes as a collateral security. Defendant number 1 created mortgage by way of deposit of title deeds relating to the scheduled property in favor of the plaintiff's company as a security. Having paid 31 installments, the D1 committed default in payment of the remaining installments. Hence, for recovery of the amount, a suit has been filed seeking a preliminary decree against the mortgaged property of the defendant number 1 and for a personal decree against all the defendants. The defendants 1, 2, 3 and 5 were set ex parte as they did not choose to contest the matter. The defendant number 4 filed written statement denying the suit transaction. He also stated that he never executed agreement of guarantee in favor of the plaintiff's company relating to the suit debt, that the suit property is not properly valued and the suit is barred by limitation. During the trial, on behalf of the plaintiff, PWs 1 to 3 were examined and exhibits A1 to A17 were marked. The defendant number 4 was examined as DW1. At this juncture, the Land Council for defendant number 4 raised an issue that the court has no jurisdiction to entertain the suit since the defendant number 1 joined as a member of chit company at Eluru on 6/1/2007 and the clause 14 of the agreement of guarantee shows that any dispute arising out of the guarantee bond shall be subjected other jurisdiction of the court at Eluru only. Furthermore, PW1 admitted about class 14 of exhibit A4 in his class examination. The learned trial judge framed a preliminary issue on the point as to whether the court has jurisdiction to entertain the suit. While answering the same, the learned trial judge was convinced with the argument of the Land Council for the defendant number 4 and accordingly returned the plaint for presentation before the proper court within 7 days. After the said return, the Land Council for the plaintiff presented the plaint stating that the suit is based on mortgage and the suit property is situated within the jurisdiction of the court and all the defendants are also residing within the jurisdiction of the said court. Hence, the conferment of the jurisdiction in the chit agreement of guarantee will not override the general law, that is the Code of Civil Procedure. The learned trial judge returned the said representation, reiterating the stand taken in the order impugned, stating that the order dated 9/8/2011 holds good and the plaintiff at liberty to file revision against the said order. Land counsel for the appellant, in elaboration to what was stated in the grounds of appeal, would primarily submit that the suit is filed for sale of mortgage property. Secondly, undoubtedly, the chit transaction took place at Eluru. The guarantee agreement also discloses that in case of any dispute, the court at Eluru only has got jurisdiction. However, that can't preclude the court from exercising jurisdiction at Tirupati. Third, the agreement between the parties cannot be override the general law, that is section class C 16 of CPC, and the parties cannot confer jurisdiction on courts which do not have such jurisdiction. The learned trial judge erred in concluding that the court has no jurisdiction under the impression that the parties conferred jurisdiction only to Eluru court. The suit being a mortgage suit, in view of the express and clear provision of section 16 class C, must be entertained before the court in whose jurisdiction the property is situated. Section 16 class C has an overriding effect on the residuary provision as contained in section 20. Coming to the facts of the present case, no doubt the chit transaction took place at Eluru, and clause 15 of the agreement of guarantee discloses that in case of any dispute, the court at Eluru only has got jurisdiction, but the fact remains that the suit property is situated within the jurisdiction of the court at Tirupati. In the light of the aforementioned premises, this court is of the view that the order impugned brooks interference in appeal. Accordingly, the civil miscellaneous appeal is allowed with cause. Having regard to the fact that the suit was instituted in 2009, it is necessary that it should be given an expeditious disposal. The learned principal senior civil judge Tirupati is directed to take the suit on file forthwith and dispose of the suit within a period of 3 months from the date of receipt of a copy of this order. Stop. If you want to get more details, more videos, subscribe our channel. Thank you.